Good morning, everyone, and thank you for joining us for our March 25th update from the Miller-Johnson Coronavirus COVID-19 Response Team. This morning, we're going to have a conversation about contracts, specifically thoughts, perspectives, and legal doctrines regarding excusing non-performance. Your panelists today are myself, Anne-Marie Carson. I'm a partner in the business section at Miller-Johnson, and I'm joined by my esteemed colleague, Amy Murphy, also a partner, although she specializes in litigation. We arrived at today's topic given the trajectory over the past several weeks. We had our first webinar specifically focusing on contracts. Over the course of the last several weeks, we've seen our thoughts around force majeure and excusing performance change given the impact of various executive orders and evolutions in each state's application of executive orders. With that, what we're going to do first is touch briefly on the executive order context. I'm going to turn it over to Amy to give us a brief highlight of executive orders. And then we're going to talk specifically about three categories within the context of executive orders that are impacting how we think about contracts and how we think about the future of business. Amy?
Thanks, Anne-Marie. We discussed a little bit before this webinar started the fact that the Michigan executive order and the other states and counties' executive orders are really priority of the day for many in the business community, given the extreme ways in which they can limit a business's operations for the foreseeable future. And so we want to talk about a couple of issues coming up with the executive orders that are shelter-in-place orders or stay-at-home orders. Frequently asked questions that we are receiving. For many of our clients, the Michigan executive order is the one that is receiving the most attention, the most need for careful analysis. And I do want to highlight that for many businesses operating now in several states, it's important to be looking not only at Michigan's order, but any state or county order that is impacting your operations outside of Michigan. That is a moving target, and so it can be tricky. We have a team here that is monitoring all of the states that are issuing shelter-in-place or stay-at-home orders or closure of business orders, as well as any county or municipalities that are also issuing those sorts of orders. So if you do have questions surrounding your outside of Michigan business operations, know that you can trust in our team's good effort to be monitoring the states that are taking measures to close businesses, as well as the counties and municipalities that are doing the same. But I do want to dive in on the Michigan executive order. We've been spending the last more than 2 days assisting clients with figuring out whether they meet the definition of critical infrastructure under the Michigan executive order. And there are some questions coming up. And Anne-Marie is assisting with those efforts too. She's been looking at the executive orders. She's been talking with companies and internally at Miller-Johnson about how those orders should be interpreted. So Anne-Marie, let's talk about some of those questions. Are there any questions that you've been getting?
Amy, I think that's a fabulous overview of, one, why this is so important to everyone in the business community, and two, why this is so complicated. I think if we could first take a look at how these orders are setting folks up to consider or effectively designate any sub-suppliers in their chain. So specifically, Amy, what I'm hoping you can touch on or debrief the group on the phone about is if it's clear that company A qualifies, what freedom does company A have to look at its suppliers and pass along the benefit of its quote unquote, designation, so to speak?
Right. So that question is a good one. It's coming up frequently. We have a lot of clients who have supply chains that they depend on or distribution centers that they depend on. And so if they are critical themselves, if their workers are critical infrastructure workers in company A, then not only does the company need to be up and running, but it needs to be sure that its supply chain and its distribution centers are also up and running. Otherwise, company A, in effect, can't keep working. So the Michigan executive order gives a business that employs critical infrastructure workers the ability to designate suppliers, distribution centers, and service providers, so long as their operations are necessary to support the critical work that the company is doing. And then in turn, those suppliers, distribution centers, and service providers who have been designated as critical can do their own designation of other suppliers, distribution centers, and service providers in the chain. So the web of companies that become critical grows as you designate suppliers and distribution centers, and as those entities do their own designations. But the important thing to remember is that there is this limiting principle. Designating any supplier or distribution center isn't permitted. It has to be a supplier or distribution center that is necessary to enable, support, or facilitate your critical infrastructure workers' work. So suppliers who are truly integral to your supply chain or distribution centers who need to be operating for you to be operating. And the order does give some warning to businesses in this area that abuse of their designation authority under this order will be subject to sanctions. So this is the one area of the order that really calls out the responsibilities that businesses have if they determine that they are critical infrastructure. So once a business is able to sort of come to the conclusion that it may operate in good faith under this executive order, it has a responsibility to do its designations consistent with the order, consistent with the need to make sure that only the people who truly need to be working on site are working on site during the term of the executive order, which right now is through April 13th.
So Amy, two questions under this bucket of designation of sub-suppliers. One, is it company A that has to reach out to the supplier or distribution center and say, you are critical to us. We need you to keep working and support these key critical infrastructure functions. B, does that supplier have an obligation to then do the same exercise internally and look at what it needs to keep running, or is there some level of cooperation expected between company A and the suppliers to determine what qualifies?
Yeah, so I think in practice, this is, for many of our clients, becoming a little bit more of a cooperative effort where suppliers and distribution centers are talking with folks below and above them in the supply chain to make sure people are on the same page and understanding what the needs are in that supply chain. But for purposes of, what does the order require? The order does require that once you've determined your critical infrastructure, if you have suppliers you think need to be up and running, you need to be making those designations. And those designations have to be in writing. And so if you are, let's say, within a supply chain, but not at the top of the chain, some lower tier in the chain, and you receive word from someone above the chain that you, above your entity in the chain, that you are necessary for for their critical infrastructure workers, you should be, one, taking a careful look at that letter, reading over the executive order and the Department of Homeland Security's essential critical infrastructure guidance. Two, making a determination, does this require us to keep running? And if so, which employees then do we have that need to be working? Which suppliers and distribution centers below us in the chain need to be working? So it can be a cooperative effort, but there are actual designation requirements under the order that need to be followed.
So Amy, I think that's a really helpful overview of that supplier designation process. One of the items you touched on is the responsibility to truly limit the designation for critical infrastructure functions. How should companies be approaching the question of what level or which workers are critical to the infrastructure functions that are approved or authorized under the executive order?
Thanks, Anne-Marie. That's another great question. So we're seeing this a lot in the manufacturing sector. Perhaps you've got a company where some of the lines truly are supplying to a critical manufacturing sector, and then some of your lines wouldn't be so easy to designate as critical infrastructure. For example, a manufacturing company that does work that supports transportation and logistics that are critical, but then also produces parts for recreational vehicles. It might be hard to say that a recreational vehicle right now is critical. So what the order requires a company like that to do is take a careful look at its employees, its staff, and determine which of those workers are strictly necessary to perform the business's critical infrastructure functions. Those are the folks that can be on the floor and need to have a written designation explaining that they need to be coming to work. If you've got employees who are not strictly necessary to your critical infrastructure function, then those people under the order, they're not supporting your critical infrastructure. They are not critical infrastructure workers. Now, slicing and dicing your workers in this respect can be difficult. And so when you do have a hard case, a gray area with workers who maybe do a little bit of critical infrastructure work, but also some work that can't really be described as critical, I think it's worth talking to your legal counsel and getting some guidance on how to step forward with this executive order and make designations that are defensible.
So, Amy, now that we've walked through the questions about a company's freedom to designate, whether it's suppliers or distribution centers, how it should be using a standard of sensitivity for the critical infrastructure functions, I wish we could leave it there, but the question becomes, for those workers that are still reporting for work, how should companies be approaching their obligations to ensure social distancing and risk mitigation is effectively being carried out?
Yeah, so this is a really important area. And the executive order doesn't just recommend that businesses take steps to mitigate the risk of COVID-19 transmission. The order actually requires businesses to adopt policies that are mitigating COVID-19 transmission. So if for businesses who are taking a look at this order, it's in section 5C of the order. It spells out social distancing practices and mitigation measures that need to be taken to protect your workers and to protect any patrons who might come on site. Those measures include restricting the number of workers to those who are strictly necessary to the critical functions, which we just talked about, promoting remote work to the fullest extent possible, to the to the maximum extent possible, you should keep workers and patrons on the premises at least 6 feet apart from one another. Here's an important one: increasing standards of facility cleaning and disinfection. And the reason I say that is important is because I think it's wise for a business to adopt a written policy in this respect and make sure your employees, especially your supervisors, are aware of those policies, have access to those policies, and know that they need to be followed to ensure that your facility is clean and disinfected. And probably the most important one that's listed in the executive order is adopting policies that prevent workers from entering the premises if they display respiratory symptoms or if they've had contact with a person who is suspected to have COVID-19 or known to have COVID-19. So this particular provision we think is worth including early and often in your communications with employees, because it's important that a company be able to defend its efforts to comply with this order and be able to say, look, we made a good faith determination, we were critical, and at the very same time we emphasize to our employees that they should not be coming on the premises no matter how critical they are to our critical infrastructure work, if they've got respiratory symptoms or if there's a suspicion they may have come into contact with someone with the virus. And so we're emphasizing say that early, say it often, say it in writing.
So at this point, I think, Amy, you've done an amazing job walking us through how companies should be contemplating designation, how they need to be thinking about critical infrastructure functions, and how they need to be carrying out their business if they do elect and qualify for these designations. So to everyone who walked through that with us, thank you. I think it would be somewhat irresponsible for us to dive into a conversation about the potential to excuse non-performance under contracts without first framing that we're in a new order, so to speak. So with that, unless, Amy, there's final words you want to say on the executive orders, I think we'll turn over to contracts specifically. What are the options for excusing non-performance? Anything you want to mention on executive orders before we pivot over to contracts?
No, I think we're good and ready to jump into the legal issues and the fact issues that are coming up with performance under contracts in this world of the executive orders.
So Miller Johnson's efforts on COVID-19 started with a look at contracts specifically. How is this going to play out with force majeure provisions? How is this going to impact the way we think about the standards of performance required in contracts? And in addition to that, Amy and a team of litigators looked specifically at how will the doctrines of impossibility, frustration of purpose, and impracticability impact a company or an entity's ability to excuse performance under a contract. We've received a handful of questions, but I think first, Amy, could you walk through how impossibility, frustration of purpose, and impracticability impact the excuse for non-performance under contracts?
Sure. So first, for our folks who are listening, if you go to Miller Johnson's COVID-19 response page, we've got links to the various articles we've been posting since the pandemic really took hold in the U.S. So on March 14th, we posted on force majeure. Our colleague in the litigation section, Jeff Muth, did an analysis of force majeure clauses in response to COVID-19. And then on for March 19th, as Anne-Marie mentioned, we put together a little primer on impossibility, frustration of purpose, and impracticability, because those are defenses or excuses for non-performance under a contract that are also relevant. let's say you've got a contract, and you're contemplating the possibility either that you're not going to be able to perform or that the counterparty to your contract is not going to be able to perform due to disruptions to the supply chain, shortages of materials, workers not being able to come to work. First and foremost, the key thing to do is take a careful look at the contract, including all of the terms and conditions. If you have a force majeure clause, then that's the clause that's going to govern. That clause is one that, in large part thinks through the possibility of a party not being able to perform due to some circumstance beyond their control that makes performance illegal or impossible.
So, Amy, let's pause on force majeure for a minute, because I think when this situation started, there were a lot of questions specific to force majeure as to whether a global pandemic would fall into the categories commonly used or listed as an event of force majeure. Now, under the new world of executive orders, we have government action. Are you of the opinion that folks should be looking back at the definition as things evolve, since we're in a little bit of a different place with what would be impacting a party's ability to perform?
Yes, definitely. I think this is a circumstance that many of us would say is unprecedented, but if it has any precedent, it's, things like the OPEC oil crisis, or really the SARS and MERS and other viral outbreaks that didn't hit the United States, but hit other countries just as hard as COVID-19 is hitting us now. And so your force majeure clause and how it is worded is a critical analysis to undertake in many states, in many of the areas of law where you're operating. Force majeure clauses are read very strictly and require, basically that you have called out this specific issue as an example of when a contract can't be performed. So a force majeure clause that describes a global pandemic or describes a viral outbreak making performance impossible is the sort of force majeure clause that's more likely to be effective in these times.
So, Amy, what about a force majeure clause that calls out government action?
That's right. Good question. And I'm sorry, I didn't address it when you first asked it. So I think that government action is, at least on its face, relevant here, because we've got, as you said, these executive orders that are demanding the closure of some businesses. But I would stress that given the way force majeure clauses are worded and interpreted under the law, to really, get your legal counsel involved in this, consult your lawyer on the relevant state's law, because the government action prong would seem to be a possibly defensible position here, but it really will depend on the state's law, and force majeure clauses are read pretty narrowly.
I think that makes a lot of sense, and I didn't mean to completely sidetrack you from the discussion of impossibility. I just wanted to make sure we touched on the force majeure.
No, it's important because it really is the primary clause to focus on if your contract has a force majeure clause. If your contract doesn't have a force majeure clause, then we're looking at these more, really they're old English common law doctrines. So we're dusting off the old common law case books, right? And thinking about doctrines that have been around for centuries. These are impossibility, frustration of purpose, and impracticability. Impracticability also finds its way into the Uniform Commercial Code So for our clients who are working in the world of contracts for the sale of goods, commercial and practicability under the UCC is going to be key. But I'll talk a little bit about impossibility and frustration of purpose first. So those are old English common law doctrines. Impossibility is pretty difficult to prove, even considering how disruptive COVID-19 has been. It requires that the performance of the contract be objectively impossible, not just financially unfavorable or impractical. So if you, as a party to a contract or the counterparty, and thinking through whether you can perform, if the question is really just, this is financially not a good fit for us, or we don't really have the resources or the energy to be doing this during the pandemic, those are unlikely to be enough to invoke impossibility. It has to be truly impossible to perform. And a good example, a court in Michigan looking at this issue said that, look, here's a company that's telling me I have to consider filing for bankruptcy because it's costing upwards of $2 million a day for me to continue to perform under this contract. And the court rejected the excuse of impossibility, just showing how high a bar it is to demonstrate an impossible performance. Frustration of purpose is a related doctrine. It's a little bit different though. So the idea behind frustration of purpose is that the party had a primary purpose for entering a transaction. The counterparty to that transaction knew about that primary purpose. And then because of events totally out of control of the party, that purpose becomes completely frustrated. In that circumstance, a party may be able to invoke the doctrine of frustration of purpose and excuse its continued performance under the contract. It's a little bit difficult to describe it in the abstract, and so I think an example is good. And the classic example of frustration of purpose comes from an old English common law case, which involved a parade where one party had rented a space with a window to watch a parade from another party who owned that space. And then the parade was canceled, right? So the party who rented the space had no other reason to have rented that space. It was solely to watch the parade. And the party who owned the property knew that. So under the common law doctrine, the party who had rented the space was able to excuse its performance to pay going forward. And that was because the contract's primary purpose, watching the parade, was totally frustrated. It's important with this doctrine to really carefully look at terms and conditions, because this doctrine can be and often is altered by the contract's language. Before we move on, do you have any questions on either of those doctrines, Anne-Marie, before we move on to commercial and practicability?
Well, I think the question we're going to hear, and we have been hearing, is, what do I do? For example, we had a question submitted. This is a little bit of a sidebar from those specific doctrines, but what do I do in a situation where I have a hotel block and I've already canceled it, but now we've reached this different reality where hotels can only operate under a certain way? I can't go back in time and undo that cancellation. So looking forward, how should I be making decisions about my contracts in this shifting legal landscape?
Right. I think, once you've canceled a contract, it will be difficult to walk that back. So when you're looking at your contracts and contemplating the possibility of a real disruption to performance, to the supply chain operating in its normal function, look carefully at which clauses are available to you as defenses, as excuses. And if it's a hard call, consult your legal team to make a determination about whether you can reserve your rights under the contract. with regard to any action you might take to end that contract.
I think that makes a lot of sense. Have you all in the litigation group been dealing specifically with questions of clients trying to navigate contract performance across state lines?
Yeah, we are seeing quite a bit of that, supply chains where maybe our client is in Michigan. It's depending on suppliers in Ohio. It's shipping goods to someone above the chain or above them in the chain in, maybe it's several states. And so these issues about performance are becoming much more complicated, right? Because it is a multi-state analysis. It does require looking to the executive orders that are governing in each state right now on whether a business can continue to operate. And of course, to the extent you're going to think about excusing your own performance, defending the ability to cancel a contract, you're probably going to be doing a multi-state analysis there too. So yes, it's coming up. We live in a world that is interstate in character for so many of us, for so many reasons. And so that's what makes this so tricky, that we don't have, the federal government sort of taking the position that applies to the entire United States. We have states and in many cases municipalities making determinations about whether businesses should remain open or closed and who is permitted to go to work. And that's having ripple effect on supply chains and on contract performance, across the states.
So, Amy, to speak specifically to one of the items we touched on in our discussion of the executive orders, you made the point quite clearly that companies should be documenting their efforts, including, if they are going to, which we recommend, but increase their cleaning protocols and their disinfection protocols under the 5C mitigation measures, that they should do so and document it in writing. As companies are facing the question of how can I or should I, or what are my options for excusing performance under this agreement, would you advise the same approach of documenting all potential mitigation efforts? Do you think that that is where the greatest value will be at the end of the day when all of this is behind us and it comes time to reckon with what the contracts were completed and which weren't?
Oh, no doubt. Any of these doctrines that excuse performance have a caveat, which is that a party who thinks it's no longer able to perform still needs to take every measure practicable to mitigate and do its best to perform under a contract, even if it's a partial performance, or make plans to resume performance once sort of they get an extension of time to perform, take steps to increase its capacity to perform as much as possible. And recording all of those efforts will be key, because if there is any litigation down the road, we'll want to be able to, put before the court all of the mitigation efforts that a party made, and all of that is key because each party does have a duty to mitigate in these circumstances.
I think that makes a lot of sense, and I appreciate the way you overviewed how this is going to be assessed when we're looking in the rearview mirror at the actions that were taken today. Do you want to speak to impracticability a little bit, or should we go ahead and start diving into the Q&A?
Why don't I just touch on commercial impracticability and let our listeners know that if they have further questions about their particular contract, they should feel free to get in touch. So commercial impracticability is an awful lot like impossibility, but it's fitting within the UCC. And so you look to the UCC section that applies, which is 2615. That excuse, basically means that it's commercially impracticable for your party, or excuse me, for a party to continue to perform under a contract. But a lot like the excuse of impossibility, increased costs, making the contract becoming much more expensive to perform, that is not enough to excuse performance for commercial impracticability. And actually, even the rise or collapse of a market is not enough to invoke commercial impracticability. Courts tend to find that sophisticated parties to a sale of goods contract, have the ability and the knowledge to accurately assess a market and its risk of collapse, its risk of rise, and negotiate for that risk. Apportion that risk, allocate that risk. So commercial impracticability is difficult to invoke, like impossibility. But one area where it came up pretty frequently is during the OPEC oil crisis. And that's because under the commentary to the UCC guidance, a severe shortage of materials that prevents a seller from securing the supplies to perform it in certain circumstances, and this is all, fact specific, may be sufficient to claim commercial impracticability. So during the OPEC oil crisis, with the, drastic and unprecedented rise in oil prices that negatively impacted many contracts, and parties in some states did have success raising a commercial impracticability defense.
So I think that was a really meaningful overview of those potential avenues for non-performance under the UCC. Looking back at the breadth of information Miller Johnson has put forward and prepared on contracts, specifically how businesses will stay up and running, I think one topic that would be important to touch on and ties into one of the questions that was submitted is, how can companies think through mitigation of damages? So for example, one of the questions we received on the Q&A for this webinar is, what happens if the circumstances cause delay to completion and not non-performance? So from a business law perspective, what comes to mind when I hear this question is, what steps is the company doing to document the causes for delay and mitigate any damages associated with a potential delay? Are there other key considerations you would add from a litigation perspective to not the situation of non-performance, but one of a delay due to the circumstances?
Your instincts are on this as good as mine. I am with you that the discussion with a client in this respect is really about documentation and fulfilling the duty to mitigate. So making sure, and hopefully, right, you're in a situation where you're comfortable talking with the parties who are expecting your performance, and talking practically about the delay, the reason for the delay, that there are these truly unprecedented circumstances that every business in America is having to reckon with right now, and just putting on the table the problems you're seeing coming down the pike, so that parties expecting your performance are on notice and can themselves take measures to mitigate their damages. So communicating with the other parties to the contract on the possibility of these problems arising is important. And then, right, taking steps in your own business to mitigate the damages that will be incurred from that non-performance. And if it means, negotiating with other parties to accept some sort of partial performance, or expecting performance, after a date, when your state's executive order, shelter-in-place order, is no longer in effect, taking those steps to communicate and plan for with parties to the contract ways in which you can make performance happen, even if it's not quite to the letter of the contract, are the key considerations.
So jumping off from your phrase of in the letter of the contract, I think you gave us a really great overview of how force majeure language is looked at and applied. Can you comment on the idea that there's often a catch-all at the end of certain force majeure clauses that leaves it open-ended, other causes outside a party's control? How will this situation be looked at in terms of contracts where force majeure has contemplated a broad catch-all such as that?
Yeah, I think that's going to be a tough one to answer without knowledge of the particular state's law, just to be candid. What I do know is that in many states, a force majeure clause, even if it has that kind of catch-all, the catch-all may not do much work for you because the law so demands that the force majeure clause have, basically predicted the circumstance that befalls you when you're considering the possibility of an impossible performance. But making sense of whether that catch-all is going to get you anywhere will really depend on the state's law.
That makes a lot of sense. And I think one thing that would be helpful to touch on with that is the situation in each state is rapidly evolving on an executive order front. So folks should be speaking with their attorneys and looking at the scope. I think this ties into what you brought up when we first kicked off the webinar, Amy, of looking at what other states are companies operating in, where do they have suppliers, what states' decisions and impacts will be affecting each company from a variety of different angles. So one question we received on the Q&A, which ties in directly to that, is how are companies supposed to process and answer requests from out-of-state customers? I know we've touched on this briefly in that it needs to be reviewed in terms of what the contract is and how the companies are designated. But is there any other general advice we can give to companies that are existing in, as you described, this very interstate economy?
Yeah, this is a tricky issue for our clients, and that's because you're making determinations right now based on the state shelter-in-place orders that affect your company about not just legally what's required of my business and what can my business be doing, what's in the realm of permissible under these orders, but also the more business-oriented and safety-oriented determinations right now. Businesses are concerned about the safety of their employees. They want to make sure their employees don't feel like they're being compelled to work in circumstances that are not safe for them. And they're also taking stock of the drastic disruptions to supply chains and workforces that are making it difficult to perform at 100%. And so when a supplier or another entity in your supply chain sends a letter and says, we need you to keep operating, that's adding another factor to your analysis of, is it wise, prudent, and lawful for us to be operating right now? And I think, it's going to mean taking the time to do that hard analysis on the executive orders that apply. Obviously, if you're in multiple states, we need to be looking at each state's order. But the business judgment issues as well. If a supplier is demanding performance and it's just not possible for your company to be up and running right now, I would really recommend consulting your legal team, because it's an issue that's thorny. It involves, not just the legal risks, but also the risk to your relationship with your suppliers or with other members of the supply chain. And we'll try to do our best to take a whole contract and holistic approach to thinking through what's the best course for your business to move forward.
And Amy, what other questions are on your mind as you think about contract performance in the context of rapidly evolving executive orders?
The thing that I keep thinking about, and it's tricky because we're not going to know for some time, is how are the courts ultimately going to look at these executive orders, and why this is, it's interesting from a litigation mind perspective. And the unfortunate thing is it will take time to get there, right? Because it means, in some cases, maybe months, but it could even be years down the road that these issues are actually coming before courts, and the courts are reckoning with what these executive orders did to businesses, how they disrupted operations, how they disrupted supply chains, how they made it difficult, if not impossible, for companies to secure the workforce they need. And so I am eager to learn how our courts deal with this issue, because it really doesn't occur very frequently that you've got circumstances as unprecedented and unforeseeable as this viral outbreak. And none of that makes it easier for our business community and other clients who are and interested parties on the line, because I'm not giving any answers. But I think it's important that we recognize, and I know Anne-Marie feels this way and talks to her clients in this respect as well, that we are extremely sympathetic to the plight that you have right now. And we are ready to be in the trenches with you, thinking through these hard issues.
I think that's a great way to describe the situation we find ourselves in. I appreciate that perspective on it. Looking at some of the other submitted questions, we received a specific question on designations, which I would recommend that individual reach out to us and we can kind of look in a little bit closer detail. As we've touched on throughout the course of this webinar, there's a lot of nuances to how critical infrastructure is able to be designated and what that means and how that plays out. We also received a question specific to paid time off, and I think Amy and I would both, I know with confidence, we would both direct that questioner to listen to the recordings prepared by our employment colleagues. And I know an additional employment webinar is in the works and will be forthcoming, addressing more of those specific questions. So tune in there for the appropriate employment law expertise and insight on that question. Amy, any other questions coming across your screen or that you want to dive into on whether it's contract performance, executive orders, or the legal state of the world?
We have so many more questions than answers at this point. It would take a long time to get through them all. I think you've done a great job in laying some groundwork on the various issues that companies are facing, and the interplay of contract performance and defense issues with the executive orders. I would encourage listeners who have questions that are specifically tailored to their contracts to reach out to us, because we have a deep team that is ready to assist you with these difficult issues.
I agree. So, thank you everyone for taking less than an hour out of your morning to partner with us as we think through the questions of what abilities and options do businesses, companies, entities have to perform under contracts in this rapidly evolving legal landscape. How are we looking at contract performance under the new climate of executive orders, which are in some cases at a state level, in some cases at a county level? I'm looking at a situation where a city borders two counties, one with an executive order, one without. It's really relaxing analysis on that one. But again, we really appreciate the engagement of the business community in these questions and discussions. Our website has a variety of resources and more will be forthcoming. But if you have specific questions, we really encourage you to follow up with your Miller Johnson attorney. Amy and I are both at your disposal as well. Our contact information is on the screen. You can locate additional information about us on the website. And, I think everyone will be doing mental gymnastics for a short period of time. And as we do that, to Amy's point, we look forward to partnering with our clients to find the best possible option for their needs. Anything from you, Amy?
Anne-Marie, just want to say thank you for leading a good conversation on these tricky topics.
I think what the folks on the webinar are missing is that these are actually the conversations Amy and I are having when we are not being recorded as well. These are questions at the top of everyone's mind, and things will continue changing, and hopefully someday we'll have more answers and questions, but until then, we look forward to working through the issues with folks. And with that, we'll sign off our webinar. Thank you for joining us.
Yeah, everyone, take care and keep 6 feet apart. Wash your hands. We're appreciative of your time today.